Bummer.
Good afternoon, and thank you for joining us. My name is Tai Sinavan. I'm the Director of Organizational and Staff Development at Standpoint. Today's webinar will be presented by Amy Eisner. My role is to funnel the questions that all of you have during the webinar. So if you have any comments or questions, go ahead and type them under the question and answer tab, and I will give them to Amy throughout her presentation. Please feel free to follow along as Amy shares her screen, or you can print out the PowerPoint. And I have uploaded the link to the PowerPoint in our chat box there. And so if you feel like that would be helpful for you, go ahead and open up that link and you can print it out or just have it on your own computer. A couple of items before we begin. I'll talk a little bit about what Standpoint is, who we are. So Standpoint serves domestic and sexual violence victims, advocates, attorneys, and other professionals across the entire state of Minnesota. We have experienced lawyers and advocates that provide support, specialized training, and also over-the-phone advocacy, and also provide legal advice, all free of charge. Some examples of the trainings we do is our annual New Laws training that we do throughout the state of Minnesota, monthly webinars like the one today, and other trainings by request. We have an action line, and that is answered Monday to Friday from 9 a.m. to 4 p.m. So we are here to assist you and individuals you serve, so please reach out to us. Another reminder is today's webinar is being recorded and will be uploaded onto Standpoint's YouTube page. The link to the recording will also be emailed out to our legal advocates listserv after this webinar, probably next week or so when it's ready to be uploaded. If you're not subscribed to our legal advocate listserv yet, please email me or call our office for information on how to get subscribed. My email is my first name, which is Ty, T-H-I, at standpointmn.org, or calling our main line at 612-343-9842. Our presenter today is Amy Eisner. She is the senior staff attorney here at Standpoint. Amy's area of expertise is in child protection, civil commitments, guardianships, family law, including orders of protection, dissolution and custody, harassment restraining orders, and representing respondents in civil matters. And so Amy has a whole range of expertise, and it's really an honor for me to work with her every day. I learn from her every single day. Today, though, she's going to be talking about serving domestic and sexual violence survivors through child protection matters. And this webinar is a continuation of the Serving Domestic and Sexual Violence Survivors Through Child Protection Matters Part 1 that we did in December. And so in Part 1, Amy discussed a high-level description of the process, procedures of child protection services from the start to the finish, from the time that CPS receives a call, a report of suspected maltreatment or neglect, through the final possible outcome of termination of parental rights and adoption. In Part 2, Amy's going to go through termination of parental rights and adoption. She's also going to continue the discussion about the players, different social workers and their roles, guardian ad litems, and other system professionals that are involved in the process. And so the goal of these two webinars is to help advocates understand this process, what it looks like, and how to best support domestic violence victims through this stressful and sometimes scary process. Yeah, so if you're ready, Amy, go ahead.
Thanks, Ty. So I wrote the description that Ty just read prior to finishing the PowerPoint, so we're not going to actually be able to get through everything that she wrote in the description, but we will do our best to get through at least this PowerPoint.
Also, there might be like a part 3.
We could do a part 3. I mean, we'll see how far we get.
Oh, love these.
So if you do decide to print the PowerPoint like Ty suggested, I would really recommend that you do one page per slide, one slide per full page. There's a lot of really dense information in this PowerPoint. There's a lot of statutes and it's very wordy. I apologize up front because it's very legalese, and I'll do my best to walk through it and explain it in a way that you'll best be able to use it to support your clients through. It does include a lot of statutory language, again, which can be confusing, so I will do my best to walk it through with you all. But do not think that after these two webinars, or possibly part 3, that you're going to understand child protection. I lived, ate, and breathed child protection matters for 14 years. For 11 years, I was a prosecutor, and for 3 years, I represented parents through the process. I've also been a guardian ad litem, and I had to do a lot of research to write this PowerPoint because things change so often. Things are very confusing, and so if you're confused, don't feel bad about it. After 14 years, I still get confused as well. And so that's why I wanted to include as much of the language into the PowerPoint so you have a place to look back to, and then call us with questions. I'll be happy to answer questions today as they come up, or also as they come up while you're working with people, to give us a call. So let's start. I'm just going to do a quick recap of what we did talk about in December. We looked at the juvenile court and how it's separate from other courts and the statutes that control it, including truancy, delinquency, child protection, and termination of parental rights, as well as children's mental health. All 4 different statutes all fall under the juvenile court rules and process. We talked about resources available as you're working with clients. That's in the first PowerPoint that was shared in a Dropbox last time as well. Building bridges with the system professionals and how to best support a survivor. We talked about building those relationships before you even have a CHIPS case so that when they come, you're able to help guide clients through that. We talked about maltreatment reporting, screening, and how family services or the child protection services screen those, the different kinds of investigations or assessments that they can do. We talked about emergency protective care hearings if a social worker or law enforcement has to immediately remove a child from a parent's custody prior to having a court hearing. We talked about what that looks like and what needs to happen. Talked about how attorneys are appointed for families in CHIPS cases and the Indian Child Welfare Act. Just saying the summary is a lot of information, so we covered a lot last time. We also talked about how there is a mechanism for social workers to file an order for protection on behalf of children under Statute 260C, rather than the parent being required to file it under the OFP statutes. That's really important to remember, and we've had calls even today about families not being able to obtain the OFP on their own, and how a second option is for Child Protection Services to go back and file that OFP through Statute 260C instead of the 518B. We talked about alternative dispute resolutions, which is different than the FENEs and SENEs in family court. So family group decision-making, parallel protection processes, and mediation. We talked about what the court process looks like and the timelines of when certain things have to be accomplished by, and the statutory basis for what a social worker needs to be able to prove in order to file a child in need of protection and services as defined under Minnesota statute. We also talked about what it looks like if a disposition, if an adjudication of child in need of protection or services is entered, or if a stay of the adjudication is entered, and how that can affect families. And so we're going to finish up the last couple slides that were on last month's PowerPoint, because we didn't get to them last time, and then move into more of the permanency options that a court can look at for children. So the out-of-home placement plan is a specific document that's supposed to be drafted together with the social worker, the parent, the child, and any other parties involved in the matter, and including the guardian ad litem, if the child is native, the tribe through the Indian Child Welfare Act, foster parents. It could include other providers too, like therapists or treatment, chemical dependency treatment, mental health treatment, stuff like that. So we've had a lot of cases come up regarding out-of-home placement plans through new laws. We've talked about several termination of parental rights cases that were overturned, and the county had to relook at things because the out-of-home placement plan had not followed this statute. So they are required to draft the document in conjunction with the people we just talked about, to submit it to the court for approval. It has to be ordered by the court, and it has to be signed by all of the parties, including the parent, child, social worker, tribe, and guardian ad litem. It also needs to be specifically explained to the people involved and what its implementation will look like. And all the parties need to understand it. So the social worker needs to go line by line through it with the family. And the family has an opportunity to object to it or to say, I don't think we need that. I think this would be a better plan for our family. And that's supposed to help guide the development of this plan. So this plan is put in place when a child is placed out of the home, in foster care, a group home, a relative's care, or with the tribe, and it is designed to provide the skills and the tasks that need to be completed in order to correct the conditions that led to the child being removed from the home and will allow for the child to be returned home. That's the ultimate goal. So it needs to set forth how the out-of-home placement plan is designed to achieve a safe placement for the child in the least restrictive, most family-like setting available, as close to the parent's home as possible when the goal is reunification, and how the placement is consistent with the best interest of the child and any special needs of the child. The specific reason why the child was placed out of the parent's home, and when reunification with the parent is the plan, a description of the problems or conditions within the family unit that required the removal from the home, and what changes the parent needs to make for the child to safely return home. It also needs to provide a description of the services that the agency is going to provide to the family for reunification, and also what they did to attempt to prevent an out-of-home placement of the child before an agency is allowed to remove the child unless it's an emergency or the child's immediately endangered. They have to try to prevent that by giving services prior to removing the child. It also has to include services or resources that the family or child requested since the time the child was removed, whether those resources were provided or not, and the basis for why they were denied. So if a parent has asked for specific services for themselves or for their child, the agency either needs to provide them or needs to explain why in this written document that will be submitted to the court why they refuse to provide it. And then the visitation plan for the child and the parent, as well as the child and any siblings that are placed in a separate location from the child, and how that visitation is consistent with the best interest of the child for the entire time that the child is in placement. So the purpose of this plan and all of these specific conditions that are associated with it are to make sure that the parent understands what is expected of them from the front end, and that we're not getting to a time where we're terminating parental rights without having made sure that they knew what was expected of them. So it needs to provide clear guidance. Also, excuse me, we're all aware that when looking at family court, the best interest of the child is paramount, and there are 12 best interest factors under child protection, under family court, that a parent needs to explain to the court why it's best for the child, whatever their recommendation is for custody or parenting time or whatever. There are also best interest standards in the child protection cases and termination of parental rights processes that the court needs to consider before making any determination for the child. For example, we'll get to later in the webinar the 3 things that the court has to find to be able to terminate parental rights, and these are one of the main 3 things. So they are different than in family court, but it's kind of the same idea. And among the factors the agency and the court need to consider the needs of the child regarding their current functioning and behaviors. Are they doing great since they've been removed from the parent? They were missing school and failing school, and now they're getting straight A's. And the purpose is not to compare the parent's home to the foster home or group home. It's not to make a parent an A+ parent. It's to make a parent who's been failing to provide for the needs of the child to reach a passing level, so like a D+ parent. And expecting an A+ parent from somebody who's had trauma or other issues that have led this far down the road would be unreasonable. And so we're not comparing, we're just looking at where the child is at right now and how can we best provide that, and can they safely be home with their parent, and would their parent be able to effectively provide this for these specific needs. The medical needs of the child, is the child have high medical needs and require special equipment or treatments or something during the day that mom isn't able to provide because she's lower functioning, or she doesn't believe the child needs them, or whatever reason she's able or not able to provide that care. If the foster parent is providing that care, mom should be in that home with the foster parent or receiving the same training that the foster parent is receiving so that they learn how to provide for their children, because the goal, unless it's egregious harm, is always reunification with the natural parent. The educational needs of the child is the third factor. The developmental needs of the child's history and past experiences. Has something in the parent's home led to trauma and PTSD, and returning there would lead to a severe emotional hardship, or have they moved past it and started reunification with mom or dad in a way that's healthy and safe for them? The child's religious and cultural needs. The goal is always to have them in a religious and culturally specific home that is appropriate to them. Although it's not black and white specific, they don't have to be placed in their culture, but the place where they are placed has to be aware of their culture and doing their best to ensure those needs are being met. The child's connection with a community, school, or faith community. Is moving them to foster home gonna pull them out of their school, their soccer team, their church, where they go every Wednesday night and see their friends? The child's interest and talents. What activities and things do they like to do, and what are they involved in? Will the parents support that? The child's relationship to their current caretaker, their parents, siblings, and other relatives. It's important to maintain those relationships whenever possible, and so we need to look at the health of the relationships when making a best interest determination. When a child is of a specific age that the court finds they're mature enough to have an opinion, if the child wants the court to be aware of what they are thinking, they get a say. Again, it's just like in family court, it's not a veto. They just get to be heard on what they want and what they think is best for themselves. And for Native children, the best interest of an Indian child is defined under a different statute, which is consistent with the Indian Child Welfare Act. I don't expect you to know all of these and memorize them, just recognize that it's important things that the court needs to look at. And if one of our clients is attempting to have their child returned to them, helping them go through this and helping them be able to explain to the court how they're able to meet each of these needs for their children might be really helpful. So in order for we're going back to last month's training again, what does the county have to be able to prove to a court for a child in need of protection or services case to be adjudicated? So they need to prove the statutory basis for determining that the child is in need of protection and services, and that's on last month's PowerPoint about the specific things that define a child to be in need of protection and services. The second thing is whether it's in the child's best interest to adjudicate them to be a child in need of protection or services, which those best interest factors are the ones we just talked about here. What services are required and appropriate for the case plan or the out-of-home placement plan? And is it safe for a child who's currently in placement to return home? Every 90 days or 3 months, the court has a review hearing and needs to assess it every time that the family's in court. Can the child return home? And they look at the case plan and whether the parent is being cooperative with it, completing any things of it, and also whether they're learning from it. If I go to a parenting class 3 days a week and I sit there on my phone and don't participate and don't learn anything, and during visits don't demonstrate that I've become better able to manage behaviors or become less abusive and gained skills to be able to discipline in a healthy manner, then that service wasn't completed. So the court has multiple options they can look at for whether it's safe to return the child. They could start visits while the child remains in foster care typically. Those could be supervised or unsupervised. Most communities have supervised visitation centers. Otherwise, sometimes foster parents will supervise, or a relative would supervise. The social workers sometimes supervise and have locations in their offices where parents can spend time with the children as well. If those go well or there's not a need for supervision, then unsupervised visits could occur several hours a day or whatever is best for that child and fits in with that parent's schedule. Eventually, they can be increased to overnights or weekends, so the child is still residing in foster care, but having regular ongoing contact with the parent in the parent's home unsupervised. A trial home visit is when the court maintains custody of the child, so they're under the care and control of the agency, but they are in the parent's home. So this allows for the social worker to be able to remove the child back out of the family's home if something were to occur during this temporary trial home visit. And if a specific period of time goes by where there has been no concerns and things are going well with the child being home, then they do return the custody to the parent. Any of these steps can be skipped and the child can be returned home the first week if after the emergency thing that led to the out-of-home placement can be corrected that quickly, as long as the agency and the court are aware that the child can be there safely. And if they can't return home after a specific period of time, for children under the age of 8, that period of time is 6 months. For children over the age of 8, it is 12 months. The court is supposed to require the agency to file for permanency. Permanency can look a lot of different ways, and we'll get to that a little bit later in the webinar. So the goal is to return them, look at the statute, the best interest, the services are appropriate, and then review regularly the placement and can they be returned home. So I said we were going to get to permanency options in a minute, so here we are. There's lots of creative different permanency options that can be available for children, but these are the most typical and most commonly seen. Termination of parental rights can be either voluntary or involuntary. A termination of parental rights means that the court has adjudicated that that parent is not legally the parent of the child. So birth certificates can be changed. The child loses all rights to inheritance unless the parent names them in a will. It is as though that relationship never existed. Mom is no longer mom. Now the agency is the parent. So this can be done voluntarily or involuntarily. If it's done voluntarily, it's typically a parent saying, I recognize that I'm not at a point to take care of my child. I love them. I want them to be safe. I know I'm not the best option, and I'm not going to fight this and drag it out. I want them to be able to have a permanent place in a family that's going to raise them. If I do it voluntarily, it doesn't affect my right to future children. If I'm young and I have a child and I do not agree to voluntarily terminate my rights, and the county has a sufficient basis to prove that my rights need to be terminated, that my child's not safe being with me, and it is done involuntarily, all future children that I have when I get older and I get married and start a family, the agency is required to file a child in need of protection or services plan at least, or a termination of parental rights based on palpable unfitness. If my rights to a previous child have been terminated, it is assumed that I am unfit to parent future children. So if a parent knows they're going to lose at trial, or their attorney believes they're going to lose at trial, a voluntary termination of parental rights is often encouraged by their attorney or sometimes by the social workers. And parents often feel blackmailed or forced into voluntarily terminating their rights. They feel like I didn't really do it voluntarily. I did it under duress. They made me do it. They threatened me. They said if I didn't do it, that they'd take all my other kids. And I know it feels like that and looks like that, but it is based on the statute, and the social workers don't have a choice. If there has been a prior termination, they at least need to file the chips, where the court is then back involved in that parent's life. So I have often encouraged people to do it knowing that they're young and that their issue is temporary and that they're going to be okay in the future, but they have some things they need to work on, and it's going to take longer than the statutorily allowed time that the child can be out of home, which again, for children 8 years old and younger, it's 6 months, and for children 8 years old and older, it's 12 months in and out of home placement. A second option, rather than termination of parental rights, is the transfer of permanent physical and legal custody to a relative. Often this happens to a sister or a grandma, mom, who's going to raise my child. It's essentially the same as if in a family court case they got sole physical and sole legal custody, except that it was granted through the juvenile process. So a relative can step up and say, I want to be the foster home for my nephew or my grandchild. And the social service agencies are required to give them an emergency license unless there's a significant reason not to, such as maltreatment determinations against them or criminal charges against them in the past. Otherwise, they have to do a regular home study and eventually license them as a foster parent and allow the children to be placed there, either under temporary custody, which they can do for CHIPS, or in a termination of parental rights in permanent custody. Long-term foster care is a third option. It's very rarely used. Public policy and the legislature believes that it's not in the best interest of children to stay in limbo and not know where they're permanently going to be. And that's why permanent physical and legal custody or termination of parental rights leading to an adoption are the most common and most frequently used. Most often, if long-term foster care is going to be ordered, it's going to be for an older child, probably 12 or older, who has their own chemical dependency or mental health issues. If their behaviors make it such that they can't safely reside at the home, but the relationship with the parent is still important, and the child's in treatment or a group home or something like that, long-term foster care can be a permanency option. In all of these, the court is required to prove, and the county is required to prove, and the court must make specific findings, meaning they write their decision and why specifically into the order regarding, again, the statutory basis for permanency, which we're going to get to in a minute when we look at the TPR statutes. Whether the county made reasonable efforts for reunification in Indian child welfare cases for Native children, the efforts made by the county need to be active, not reasonable. They need to take a further step and be providing more to a parent of a Native child and the best interest of the child. It's very counterintuitive and it feels very gross to parents and often outsiders looking into the system that a social worker working with the family is doing both reunification planning and permanency planning. And that's because of the public policy of children needing stability and consistency and a permanent home. And so for the 6 months for a child under 8 or the year for a child over 8, the same social worker who's working with mom to try to get her the services that she needs to be able to safely have the child return is also at the same time looking for a permanent option for the child if the child is not able to return home. So they might be working with grandparents on getting their home study established. They might be working with making sure that the foster home the child is in is one that's willing to adopt the child. And if they're not, moving them to a foster home where it could be a permanent option. So it's called concurrency planning when they're doing both reunification efforts and permanency planning. And I don't believe that we've been able to find a good way to do both at the same time without making parents feel invalidated and mistrustful. So that's one of the barriers in these cases. So egregious harm is a specific basis for a termination of parental rights and often leads to the immediate removal of a child from their home. It also is a basis for the court to make a finding that the agency, the county, does not have to make reasonable efforts at reunification. If egregious harm has occurred to a child, it is presumed that that parent is unfit for that child and all other children to be a parent. And so we'll go through some of what those egregious harm definitions are under the statute, which I've put on the slide here. So it means the infliction of bodily harm to a child or neglect of a child, which demonstrates a grossly inadequate ability to provide minimally adequate parental care, which includes but is not limited to the things that they include in the statute. So if there was something else that occurred besides the things I mentioned, if they determine it's egregious harm, they don't have to provide efforts to reunify. Again, these are actions towards another child or the child. So actions towards the parent or towards another adult don't count, but actions towards even an unrelated child would count. So first-degree murder or assault in the first, second, or third degree, which causes great bodily harm or bodily harm. The infliction of substantial bodily harm, which is injury that involves a temporary but substantial disfigurement, like a broken bone, or which causes a temporary but substantial loss or impairment or fracture of the body part. So again, a broken bone, a concussion. It has to be more than bruises, but a significant injury to the child. Felony malicious punishment, which is intentional acts or a series of acts with respect to a child that shows unreasonable force or cruel discipline that's excessive under the circumstances. A lot of these seem very subjective, which is why we have a system where the court is making decisions about whether reunification needs to happen, and the agency can't just say, well, I think it was excessive. A court has to say it was excessive as a counterbalance and protection. Felony unreasonable restraint, including intentionally subjecting a child to physical confinement or restraint, such as tying them up, locking them somewhere, or caging them, or chaining them for a prolonged period of time in a cruel manner, which is excessive under the circumstances. So this statute seems bizarre to me because I think if you tie, lock, cage, or chain a child for any period of time, it's by its nature cruel and excessive under any circumstances. But again, it's a very subjective thing that a court's going to make a decision about. Felony neglect is the willful deprivation of necessary food, clothing, shelter, healthcare, supervision that's appropriate for the child's age and needs when the parent is able to make the necessary provisions. And the deprivation is likely to harm the child's physical, mental, or emotional health. So they specifically say that the parent has to be able. So if I can't provide it because I'm homeless, or I can't provide it because we're in poverty and I can't afford to take my child to the doctor, I can't afford maybe a winter coat or clothes that fit or food, they're going to provide me services instead of determining that my behavior is so egregious that they need to terminate parental rights. Also, if the parent, based on their faith or spiritual beliefs, deems that they're not going to use traditional health care, they're going to use prayer or other remedial care for the child's medical needs, that is allowed as well. A parent who knowingly permits someone else to physically or sexually assault their child is guilty of felony neglect, or if they intentionally or recklessly cause or permit the child to be placed somewhere where their physical, mental, or emotional health is likely to be endangered. For example, leaving my child alone with a predatory offender, someone who's on the sex offender registration list, and I know that, and I leave my child with them. That's felony neglect. Felony endangerment is when a parent knowingly causes or permits the child to be present where drugs are being manufactured, sold, or dangerous items that are there that are used for the manufacturing of controlled substances. This statute came out when meth started to become a large epidemic. So the battery acid and the Sudafed and the hydrous ammonia and other things that were used if they were in the home, the parent was engaging in felony endangerment of the child. If a child's less than 14, allowing them to have access to a loaded firearm is also felony endangerment, which is weird to me because I think that you can hunt younger than that if you go through the classes and stuff. But I guess if you're with them and trained, you're not putting them in a situation likely to substantially result in harm from the firearm. So that's why that's allowed. Again, some of these are repetitive. I took all the statute numbers out and put language in to make it less confusing on the PowerPoint. So assault 1, 2, and first, second, and third degree again, which was the first one. Egregious harm includes solicitation, inducement, or promotion of, or receiving profit from prostitution. Murder or voluntary manslaughter of a child. Again, that was number 1. Aiding and abetting or attempting, conspiring, or soliciting a child to commit murder or voluntary manslaughter. You can't have your kids go kill people for you because they're minors, so they'll get in less trouble. Or criminal sexual conduct towards a child. So egregious harm covers all of those things, and egregious harm is just one of the bases that a county can file a petition for termination of parental rights. So we'll get into the termination petitions and what has to be proved and when services are required and when they're not. Are there any questions at this point, Ty? I must not be with us. Okay, for termination of parental rights, there's a specific petition with, and statute, which is 260C.301. Subdivision 1A talks about voluntary termination of parental rights. We're not going to cover that. We're looking at the involuntary ones under subdivision 1, parens B, which says that the court may terminate all rights of a parent to a child if it finds that one or more of these statutory bases are met. The parent has abandoned the child. Mom left child with aunt, said she'd be back the next day, didn't come back. Aunt can't care for the child placed in foster care, mom never shows up, county can't find her. 2, that a parent has substantially, continuously, or repeatedly refused or neglected to comply with the duties that come along with being a parent, like providing food, clothing, shelter, education, and other care and control for the child's physical, mental, or emotional health and development. Again, so long as the parent is financially and physically able to do so, and reasonable efforts by the agency have failed to fix that. And reasonable efforts would be futile and therefore unreasonable. So the agency's been providing services to this family for a long time. It's not getting better. It's no longer reasonable to keep doing the same thing over and over again when nothing's being corrected. A third option is that the parent has been ordered to contribute to the support of a child, so child support, and without good cause has failed to do so. But this has to be court ordered. So mom, they get divorced, dad's ordered to pay child support through the divorce decree. He doesn't, he never has, he never will. He can't later come in and say, well, I want custody, I want the child to be placed with me if it can't be with the mother. You forfeited that right through child protection by not providing for their needs without a good reason. A fourth reason is that the parent is palpably unfit. This is the one I talked about earlier, that if a parent has had an involuntarily terminated parental rights previously, it's assumed that they are, again, palpably unfit to care for their child. If they've not had one, they can be found to be palpably unfit due to a consistent pattern of conduct before the child or specific conditions directly relating to the relationship between them and the child, which has been going on for such a long time or is so extreme that it renders the parent unable in the reasonably foreseeable future. They might be sometime, but the child can't wait around forever for the parent to care appropriately for the physical, mental, and emotional needs of the child. You see that over and over again in these statutes, physical, mental, and emotional needs. Through child protection, you'll also see health, safety, and welfare as being a standard that's looked at a lot. So when you hear those, they're based in statute, and that's the things they're primarily looking at. Another one is that following the child's out-of-home placement, the agency's done everything they can. They've provided reasonable efforts under the court's approval and direction. The parent has failed to correct the conditions leading to the child's placement. It's presumed that reasonable efforts have failed when the following things have been shown. A child less than 8 years old has been out of the parent's home for a period of 12 months. Over 8 years old has been out of the parent's home for a period of 12 months within the last 22 months. So it doesn't have to be 12 months in a row. If over the last a little less than 2 years, they've been out of the home for 12 months, that's sufficient. Or a child less than 8 has been found to be a CHIPS child and has resided out of the home for 6 months. Unless during that time, the parent is maintaining regular contact with the child and is complying with the out-of-home placement plan. If the parent is maintaining significant relationship and contact with the child and is following the case plan but has not yet achieved the goals to make it safe for the child to return home, but they're doing everything they can, there is a way for the court to extend these time periods, but they have to make a specific order saying what needs to happen and that it's in the best interest of the child, that remaining in out-of-home placement is less harmful to the child, with reunification remaining the goal, than terminating parental rights prematurely would be if the child can be returned home. So reasonable efforts are presumed to be unsuccessful if the child's been out of the home that long. The court has approved the out-of-home placement plan pursuant to the statutes we looked at a little bit ago. The conditions leading to the out-of-home placement have not been corrected, and reasonable efforts have been made. Those timelines that we talked about do not prohibit the county from filing a termination of parental rights or other permanency petition earlier than those dates. If a parent is clearly not interested or willing to do anything to correct the home so that the child can come home, they don't have to wait 6 months or a year to do so. Regarding chemical dependency, there's its own special part of the statute where reasonable efforts are assumed to have failed if the parent has been diagnosed by a professional to be chemically dependent. The case plan requires them to participate in a treatment program. The treatment is culturally, linguistically, and clinically appropriate. And the parent has failed twice to complete treatment or has been offered treatment by the social worker 2 times and refused to go. And the parent continues to abuse chemicals. If those 5 things have taken place, it's assumed that reasonable efforts have failed and that further efforts aren't needed or required by the statute, and that a termination of parental rights order could issue. If the child has experienced egregious harm in the parent's care, which is of a nature, duration, or chronicity that indicates a lack of regard for the child, that any reasonable person would be so astonished and appalled by what the behavior was, and any person would think it's not in the best interest of this child to be placed with the parent. Again, those, I think it was 3 slides we went through about egregious harm. That's what those things are referring to. In the case of a child born when the parents are not married, there are specific statutes, 259.49, which require the non-married father to register with the father's adoption registry under statute 259. If the father fails to do that, he is not entitled to an adoption hearing and is not made a party to the termination of parental rights proceedings. If he's been involved with mom and engaged in the child protection case or engaged in the child's life during the time the child was with mom, he can intervene and ask to become a party and ask to be considered, even if he's missed this very short timeline that he has to register with the father's adoption registry. But if he just this is why we encourage people who have engaged in a lot of sexual encounters to go register, because you could later find out that you have a child, not know anything about it, and not be entitled to any access if the mom's rights are terminated, either voluntarily for an adoption or involuntarily if you haven't registered. And you may very well not know that child exists. So if you want to be an involved father in any potential child resulting from any sexual encounter, you have to go register with the father's adoption registry if you want to be considered.
Amy?
Yes, Ty. You
I
scared
know
me.
you. No, I just wanted to pop in quick because I knew you went to the next slide, and I know you were asking me. I got a urgent call came in, and I was taking that, and so I heard you, but I wasn't able to respond. There is no questions at the moment, just so you know that, okay?
Thank you. Scared me.
No,
Okay.
sorry. I'm really good at doing that.
You are, yes. I didn't scream though. Okay, so an 8th basis, statutory basis for a termination of parental rights is that the child is neglected and in foster care. Child's been in foster care, parent left, they're not cooperating with social services, they're not seeing the child, they have rights to visits, they're not visiting, and it's no longer in the child's best interest to just hang out and wait for the parent to decide at some point they want to come back. Or the parent has been convicted of a crime listed in one of the TPR statutes. Then a lot of these are the same as the egregious harm language, so I'll just go through them quickly. And again, I'm sorry that this PowerPoint is so wordy and statutory based. I just wanted you to have it so you could see it quickly and then know to call us and ask questions regarding any of this. So once the court determines that reasonable efforts are no longer required, it has to be based on egregious harm or based on some of the things that we talked about in the prior 3 slides, or that the parent has been convicted of one of these crimes. And there is no requirement to attempt reunification or reasonable efforts when they have committed attempted or conspiracy to commit murder in the first degree, manslaughter in the first degree, assault in the second degree regarding a child. And this one says a child of the parent. The egregious harm one says a child under their care. So it could be a stepchild or they're a teacher or a girlfriend's child or something like that. So this one requires a child of the parent. substantial bodily harm, a pattern of harm, assault in the second degree to a child under 4 years old, a violation of or an attempt to, or conspiracy to commit federal murder to another child of the parent. I'm not sure how federal murder is different from Minnesota murder. I think they're similar, but it's in here specifically. Or they've committed sexual abuse against the child or another child of that parent. Subjection of a child by a person responsible for their care, or by a person who has significant relationship to the child, or by a person in current or recent position of authority, to any act which constitutes criminal sexual conduct in the first, second, third, fourth, or fifth degree, or solicitation of children to engage in sexual conduct, communication of sexually explicit materials to children, any act that involves a child in prostitution, any known or suspected child sex trafficking and not protecting your child from it, threatened sexual abuse, including residing with a person who's required registration as a predatory offender, or being yourself the person who's required to register as a predatory offender. So this one requires a conviction, and we'll get at the end, we'll talk about how there's lots of different intersectionalities between the juvenile court proceedings and other legal proceedings. And this is one example where the child protection case may linger and wait pending a conviction of a parent in a criminal case. If a parent is convicted in a criminal case, the state has proved beyond a reasonable doubt that they've committed this crime. If you want to use that conviction to terminate their parental rights, you obviously have to wait for the conviction to be entered. And so the child may be in foster care for a while waiting for that criminal matter to be completed. So the court process and the timelines, these timelines are very specific. They are intended to be followed. They are not often followed. I think that courts want to err on the side of caution and make sure that children are safe, but also realize that terminating someone's parental rights is an extreme step, and that we only want to do that if we have to. And so if we can extend the timelines, that's frequently done. So an admit-deny hearing on the permanency petition. So they file a CHIPS petition. They've been working with the family for a year now. The child's still not able to be reunified. They have to file a new petition for permanency. So within 12 months of the child being placed in foster care, if they're over 8, the admit-deny hearing on the permanency petition needs to occur. The admit-deny hearing has to be held within 10 days of the filing of the petition. If the court determines that there's a prima facie basis to discontinue reasonable efforts, they can do so. If not, even though they're proceeding to a termination of parental rights, that concurrency planning still needs to continue. And unless the court makes a specific basis and specific findings of reasonable efforts are futile, are no longer reasonable, or are not required by nature of one of the statutes we went through, the court can discontinue that. Otherwise, they have to continue until a final order in the permanency petition proceeding is completed. Within 60 days, 2 months of the admit-deny hearing, the trial is supposed to occur. And if the termination of parental rights or other permanency is granted, if the court has determined that the child cannot be returned to the home of the parent, they need to make one of 3 adjudications. They can terminate all rights of all parents to the children, and the children are then placed under the guardianship of the Commissioner of Human Services. Typically, the adoption social worker is a different social worker through the county than the social workers that have been working with the family up until this point. The adoption worker acts as the agent on behalf of the Commissioner of Human Services to be making plans and ensuring things for the child. So they might be signing permission slips. They are making determinations about where the child's going to live. They're making recommendations and coming back to court every 90 days until an adoption is completed. An alternative to a termination of parental rights is one of the other permanency suggestions that we talked about earlier, or bases that the county can file. So if the county files for a termination of parental rights and the court deems that the county has proven their case, they don't have to do the act which the county requested. If the county asks for a termination of parental rights, the court can still say, I'm not terminating parental rights, but I am giving grandma permanent custody. And any changes in custody that are going to take place are going to take place before me in juvenile court. So mom can't go into family court and try to change it and get custody from her mom without the juvenile court knowing. Once the juvenile court knows, they will notify the social worker and the guardian ad litem and the other parties so that the court who heard all of the concerns regarding the parent is the one making the decision of whether a transfer back to mom would be appropriate or not. Or permanent custody to the social services agency. Again, those children typically who are 16 and over who don't want to be adopted or refuse to consent to adoption. A child, I thought it was 14, but I wrote 16, so the statute must have changed since I did this. If a child refuses to be adopted, they cannot be forced to be adopted. Or if another child is unable to be placed for adoption, their needs are so significant that 24-hour awake care is required. They might have to be placed in a group home or something like that. So those children can be placed under the permanent custody of the social work agency. And the parent can't get that custody back. But if that happens, sometimes parents can still be engaged in communication with the child and stuff like that. So those two, custody to a relative and permanent custody with the agency, are going to look different for every parent based on what the needs of the family were, based on the safety of the child, and why contact has to stop. I'm just going to keep blowing through this, Ty. If any questions do come, please just interrupt at any time.
Yes, and we don't have any questions now, so
Okay.
continue.
We have 34 minutes left. We're going to see how quickly we can get through this, but also I want to be respectful to make sure that it's understandable. So if we have to do part 3, we will. After a permanency determination has been made, parents have a right to appeal. And that is governed by the Minnesota Rules of Civil Appellate Procedure, which is weird because it feels more like I think of torts and suing people and employment and other things when I think of civil, but civil also includes juvenile laws. So after the permanency order has issued, the parent has 60 days to file a notice of appeal with the Minnesota Court of Appeals and serve it on all the other parties. After they give their notice, which basically just says, I disagree with this, I'd like to file an appeal. It doesn't have to be a long, detailed brief or explain their legal reasoning. After that's filed, they need to request the transcript of the trial. So the court reporter would type up everything that was said during the trial. They also provide a complete copy of the file to the Court of Appeals, and all of the parties receive a copy of the transcript. The disposition is stayed, which means that it's still ordered, but it's not going to move forward until the appeal has concluded. So if a parent's rights have been terminated, the child would normally be available for adoption. But the adoption can't progress and move forward when an appeal is pending, because the appeal kind of stops everything. We're going to wait and see if the court did everything right. The only basis to appeal is that the court made an error. They didn't follow the law, they didn't follow the rule, they allowed so much evidence in that should not have come in, that I was not treated fairly in the trial. If they'd only looked at appropriate evidence, the county would not have been able to prove their case, things like that. Not just because I disagree or I want my child back. It is always, always, always best for a party to have an attorney if they're going to do this. And there's some attorneys who kind of specialize in this. In certain communities, whenever a termination of parental rights is issued, the attorney will get the parent to consent that they can go appeal it for the parent. So the appellant is typically the parent. They're the one arguing that the court did something wrong. After you get the transcript, you have 30 days to file the brief, which is written by the attorney. It's a detailed description of the law and what the court did wrong. So having the transcript available, you cite to the page that the court said something that wasn't properly under the law, or you cite to the document in the court file that should not have been let in, or whatever. So we're at 90 days now before mom even has to file their brief, and it can take 60 or more days to get the transcript, so we might be at 5 months out by now. The respondent, which is typically the county or the state, has 30 days after that to file their brief with the court. So we're at 6 months, and then the appellant, the parent, has 14 days to file a responsive brief. So they say what's wrong and why they think the court should overrule the lower court. The county says, nope, the court got it right. Their right should be terminated, and argues against all the things that the parent's attorney said. Then the parent's attorney gets a chance to respond to what the county said. After that, oral argument will be set. It could take a month or two to get that on the books. And then after the oral argument is completed, where both attorneys go in front of the Court of Appeals and have not very much time, but about 15 minutes each, to describe why the court was right or wrong and why the court should affirm or overturn the lower court. Then the Court of Appeals has 90 days, 3 more months, to issue their order. Once that order has issued, if a party doesn't agree with what the Court of Appeals says, they can ask to take it up to the Minnesota Supreme Court. And you can't just file an appeal with the Supreme Court like you can with the Court of Appeals. You automatically get an appeal if you want one with the appellate court, the Court of Appeals. But if you want to go higher, you have to ask them permission. So you write a letter requesting, it's called certiorari, or I don't really know how to pronounce it. We just say cert. And then the Minnesota Supreme Court says either this is a significant issue of constitutional importance or statutory importance or something that affects the entire state and all future child protection or termination of parental rights cases, not just this parent. And so we're going to take it, which is very, very, very rare. Or the court might have done something wrong at the lower level, but the Court of Appeals addressed it and it was very case specific. So we're not going to take it. It doesn't address something that the Supreme Court needs to be involved in. That being said, all of this can take well over a year. So a child could have been in foster care for a year, and then the court found reasonable basis to extend that time, maybe 6 months or another year. Then the trial occurs and the court terminates their parental rights. I forgot to mention that after the trial, the district court who heard the trial has several, I don't remember because I didn't look up the number of days, but quite a while to issue their order. I think it's 90 days, but it might be faster in CHIPS. So the child could be in foster care for over 3 years by the time adoptive placement is even able to file their petition to ask for adoption. So for children, that can be fine, because they don't know if some paper says that you're my mom or not. I've been living with you for 3 years. I don't remember my mom. I think you're my mom. I call you mom. But most kids do know if they're legally adopted by the family, and it can be really stressful to them to like wonder, are you really going to keep me? Do you love me? Are you my mom? And so over the years, the legislature has tightened up these deadlines and made them shorter than they are in most other kinds of cases, but it's still really hard for kids. It's also very hard for parents, especially if they're trying to work the case plan, but the time runs out and their children are terminated from them. So our clients face this a lot. One thing I told you in the December webinar, and I encourage it again, is encourage them to cooperate with the agency as much as they can, whether they agree with it or not. Ask, how high do you want me to jump? I'll do anything for my children, because resulting in a permanency order where the children are no longer legally your children is very detrimental to our clients, particularly if this has arisen out of a domestic violence situation, which most of the people we're working with it has. So adoption. When a termination of parental rights is issued, the child is placed under the custody of the Commissioner of Human Services. Again, that adoption social worker at the local agency is going to work as the agent for the commissioner, and be going back regularly to court for the court to make sure that the process is going as it should and that it's timely and moving forward. So a person who wants to adopt the child has to go through a background study, and eventually, if they pass the background study, then a full home study. Typically, people who are engaging in foster care on behalf of the county, or for a lot of licensed agencies such as Lutheran Social Services or other private agencies that then contract their foster parents with the county, have already done this background study and home study. So it may just need to be updated if more than a year has passed since they initially got their home study, to keep it active if one of the children in their home they would like to adopt. So while the child is pending, regular review hearings are held every 90 days in front of the court. And the court is making sure that the agent from the local service, the child protection agency, is making reasonable efforts to finalize the adoption. So making sure that the child is still in the best home, that this family really does want to adopt, that they're meeting all the needs of the children, that they're getting counseling and school and medical and everything the child needs. After all appellate issues have stopped and the child is actually legally free for adoption, then that adoptive family files a petition seeking adoption, and a court hearing is held. Typically, all the paperwork is drafted and complete, it's all in order, and it ends up being a ceremony or a fun event where the child gets to sit on the judge's lap and the judge signs the paper saying that's your forever mom and dad. There are lots of requirements also about adoption, which also are supposed to be occurring during the child protection and any permanency trial proceedings, keeping kids together. And we'll talk about that in another slide. We talked about it at New Laws a year or two ago. But it's important that if a child is no longer able to be with their parents, that they're still with their siblings and that there's still a connection between each other. So the Foster Care Sibling Bill of Rights is a new statute, 260C.008. And the rights include that they have a legal right under the statute to be placed with their siblings when it's possible and in their best interest. If they can't be placed together, to be placed in close geographical distance. So sometimes they can't be placed together because there's 8 of them and no family is able to adopt all 8 children. Sometimes they can't be placed together because it's not in their best interest. One of them may have harmed or be at risk of harming another one. They still should be placed close together in the same town, in the same community. They are given a right to have frequent contact with their siblings, whether the siblings are in foster care or not, unless it's not in their best interest. So they might have adult siblings who aren't in foster care, who they have a right to have regular contact with. Or they might have siblings who are placed in a different foster home, and both of them share the rights to have a relationship with each other. They are given the right to receive a phone number, address, and email for all of their siblings, whether in care or not, receive updated photographs of their siblings, and have regular mail or email exchanges. Those updates are supposed to be provided at least once a year. And whenever possible, they have a right to receive regular face-to-face visits with all of their siblings, whether in foster care or not. And it cannot be withheld as a consequence for their behavior, and can only be restricted if there's documentation that the visits are harmful to their safety or well-being, or that they are harmful to the safety or well-being of another sibling. These are rights. The word right is a really strong word that's intentionally put into this legislation. Kids get to see their siblings. They also have a right to be actively involved in each other's lives and share celebrations if they want to. So maybe high school graduation, quinceanera, confirmation, wedding. They get to participate. If one of the children is moved from one placement to another, all other siblings need to be notified of that, whether it's from a foster home into a group home into a foster home, or one foster home to grandma. Wherever they're moved, the other siblings get to know. They get to be included in permanency planning decisions for their siblings if that's appropriate. That's humongous. Permanency planning means like, yeah, I think that family should adopt them. They're great there. Or I think they should go live with grandma even though I can't. Or whatever. They get to be part of that discussion and have a say in it. They probably don't get much of a say, but they get to be included in it. They get to be informed of the expectations for and possibility of continued contact. So all these prior things that we said, they have a right to know about them and be provided with notice of their rights. And that if you harm a child during visitation, you're not going to get to see them again because we can't let that happen. And adult siblings have right to be considered as foster care providers. I've seen that a lot, particularly in some cultural families where the older sibling is saying, yeah, I'm 21, but I will take care of them. And they have to be considered. They can't just be sent away, you're 21, you can't do it. They are given this right. Another new statute that came out, we talked about it, new laws this year, I was very excited about, but I need a drink first, hold on. Is the reestablishment of parental rights. So if a parent has lost parental rights, the court has terminated their parental rights. They can reestablish them if the child is not adopted. So a parent whose rights were terminated can file a petition to reestablish the legal parent-child relationship if they can show the court that they have corrected the conditions that led to the TPR, that they're willing and capable to provide day-to-day care and maintain the health, safety, and welfare of the child, that the child has been in foster care for 4 years after the termination of parental rights order, and they haven't been adopted and are not the subject of a written adoption placement, and the child wants to reside with the parent. So I was really messed up. I was doing meth. I couldn't get clean. My abuser was still around and harming me, and I needed the meth to medicate. He finally was deported, but the parental rights of my child, my rights to my child were terminated before I got clean. Since I'm no longer being abused and in that relationship, I've had time to work on myself and heal. And for the last 4 years, I've been sober. My child still hasn't been adopted because of his trauma from watching me be abused and himself being abused. And he's been through a lot of treatment and stuff, but he sabotages all of his foster care placements because he really wants to be with me. And so he can't get adopted. And he really wants to be with me, and now I can do it. It's been 4 years. I'm sober. I'm clean. Neither of us are going to be abused. And if I can convince the judge of that, they can give my child back to me, which is incredible because termination of parental rights, sometimes it's so extreme and it's so sad that it's considered like almost as bad as the death penalty. It's a lifetime sentence of losing your child. So having a way to restore that relationship, I think, is amazing. I don't know if it's been successfully done yet. It just came into effect in August, but I am happy to see that the legislature has recognized the importance of restoration when that can happen. So what other laws happen and can interfere or intersect with the child protection process or the permanency process? So lots of different things can come up. In the first webinar in December, we talked about how when a child protection matter is filed, it brings all other family law matters to a screeching halt. The court can't address custody or parenting time in an order for protection when child protection has filed a CHIPS petition. That needs to all take place through the CHIPS petition. I can address a divorce case. I can get divorced and address the financial stuff, but I can't address custody or parenting time in a divorce case until the child protection matter has closed. Or I can do it in the child protection matter separate from the divorce. However, there's other areas of law that do take place at the same time. So a criminal matter, if we talked about it before, if a parent's accused of a crime, sometimes the court might wait until the conviction or that trial is done to then proceed with the CHIPS action. They might keep the children in foster care, review it every 90 days, recognizing that nothing's going to move forward until that criminal matter is done, which can create longer periods of instability or lack of permanency for children, but also your rights to your children shouldn't be terminated if you didn't do it just because you've been accused of doing it. Immigration. A lot of families get concerned that being involved with child protection will lead to immigration being in their life, or that if they get deported, child protection will take their kids instead of whoever they designate as a caretaker for their kids. I have had cases, this was many, many years ago when I was practicing. Mom was deported, the children were placed in foster care, and we attempted reunification of mom in Honduras, but it wasn't able to take place because she wasn't getting better and the social workers in Honduras were saying she can't have kids. We ended up doing a trial by phone with her in Honduras at the consulate and us in the courtroom and Spanish interpreters. That trial took a real long time and was complicated because of the immigration issues. It also complicated the children were adopted, but were not US citizens and were not here with papers. So what do you do with that? That was the social workers' issue to figure out. So criminal and immigration can proceed. Housing could be proceeding. I'm getting evicted from my home. I need to try to get this eviction off my record so I can get housing so that I can have my kids home and I'm not homeless. So there's lots of things. We have lots of calls from you advocates and clients even who are involved in child protection matters. They almost always have an attorney for the child protection matter. And so the attorneys here are not able to give legal advice to them regarding how to deal with that. We're always happy to talk to the attorneys representing them and help them understand DV and SA and the dynamics of trauma on the family, but we can't give legal advice to the client directly. We can give that client legal advice about housing because they don't have an attorney regarding housing. We can give them legal advice about OFPs and HROs because that's not related to the child protection matter. So just recognize that we're not able to give them legal advice. We've had several callings saying somebody told them to call here, and then when we're not able to help them, they get frustrated, which is understandable. But you can always call. We can give y'all legal advice and talk through how to help them navigate this process. We have 12 minutes left, and we've arrived to a picture of a puppy, which makes me very happy. Are there any questions?
There are no questions.
Okay, so do we want to give everyone a minute to decide if they want to send any in, or do we want to just allow people to email you or the listserv and I can respond to them that way?
Yeah, I mean, no pressure for people to have questions now. So I'd
Okay.
say it's safe for us to go ahead and in the webinar now, if you do have questions, our action line is open Monday to Friday, 9 a.m. to 4 p.m. We also take emails as well. So there is Amy I's email and then also the Standpoint MN, well, that's our website, standpointmn.org. That is our website. But our info email as well will come to our email.
info@standpointmn.org.
Yeah, so we will take emails or you can call our 612-343-9842. But Amy has also put her direct number in there as well for contact if you want to reach out after today. Thank you for joining us.
Yeah, thank you. Hope you all have a nice long weekend.
Yes, stay warm.
Bye.